and welcome to today's second open forum on data privacy. This is hosted by the Information Technology Division. My name is Jeff Kimball. I'll be your host this morning. We have a lot of activities on slate for today, starting with Mark Wallman. He's going to be presenting, and he is the Interim Vice President of Information Technology. He'll be presenting on managing electronic communications. Following him will be Christopher Wilson from the... Followed by Christopher Wilson from the General Counsel's Office. He'll be presenting on open records requests. Following that, Teresa will be speaking on behalf of Eric Miller from the Director of Ethics, Compliance and Audit on records management. Following these three presenters, we're going to have an open forum where these folks, along with Stephen Hammer, a PhD candidate who served on a committee. If you want to describe that committee that you were on, Stephen?
Social media. Yeah, we had a committee last semester where we worked on the guidelines and best practices of social media use in the classroom.
Okay, Stephen is a PhD candidate and he's an instructor with the English department. After these people present, we're going to have a time where you can answer questions, or we'll be answering questions from the audience on data privacy concerns that you may have. Without any further ado, please welcome Mark Wallman on managing electronic communications.
Thanks all for coming. This is a presentation I gave a couple other times. I've shortened it a little bit because we have some experts in the room here, like Chris and Teresa, who's sitting in for Eric Miller. And I've gotten a lot of questions since last summer about electronic communications and about privacy and about who can see what, and then it just bleeds over into all sorts of areas, records retention, all sorts of stuff. So that's basically what we'll be going through today. Just to kind of start us off, I just kind of have a list of various forms of electronic communication: email, instant messaging, voicemail, text messages, video chat, learning management systems. All of these may be producing records that may be subject to open records or other laws. And so this is kind of the framework of all these things, and there's a lot more than this. It's just kind of a sample of things that are going to be producing records, and then there end up being privacy and all these other concerns. So the concerns really are privacy, open records, records retention, incidental use, and personal devices used for work. So the privacy concerns are really who can see my data, what can they see, and how do I know that the people who can see my data without my knowledge are being responsible. So for third-party services, like Google, or excuse me, Dropbox, Box.com, iCloud, a personal Google account, there's lots of others. There are a third party who's not part of NDSU who can see your data. And if you're using any of these services, it's important to recognize a couple of points here. We cannot tell you who can and can't see your data. The terms that you are using these services under may violate state or federal laws, and you may be exposed to risk unassociated with services managed by us. You're also responsible for protecting the data and producing as required by applicable laws. So for services we manage, or for services that NDSU manages, it varies from service to service what the administrators can see. So for some services we have full access. Blackboard is one example. Some services, IT staff have limited access, and NDSU staff in general. People admin, the jobs portal is an example. That's an outsourced service. HR payroll has some level of administrative access, but they don't have the same level of access that the vendor does in that case. So focusing just on our IT staff, and this is really for all employees in the university system, not just IT staff, not just central IT staff, not just NDSU, but are expected to follow the NDUS procedure 1901.2. And for NDSU, we have two additional policies, 158 and 710. One of those two has to do with an acceptable use policy, and it outlines what's allowed and what's not. All of the central IT staff have signed a confidentiality agreement, and it's on file, and we review the expectations at all staff meetings. We've done that twice in the last 12 months. So this is the actual 1901.2 policy, and the rule is that we should not be monitoring, that your data should be free of monitoring unless there are certain requirements that are met. So meet the requirements of state open records laws. We monitor to protect the integrity of the college, university, and the rights of and property of the state. And here where it's talking about the integrity of the college, university, so folks know that really means in an IT sense. So when we talk about integrity, we talk like about a database, that if the database has what we call referential integrity. So if there are little pieces of data strewn throughout the database, they can all be reassembled into a larger thing. So if it's just storing like names and addresses, for example, or actually they can go to Blackboard. Blackboard, if its database has its integrity, we could actually take a student and tie that to the student's grades for particular courses, which is probably stored within the database, but not stored in a way that's coupled with the person's name, for example. So we're talking about integrity of the college in an IT sense, not, oh, somebody's embarrassing us and we don't like it, we're gonna go look. Third is allowance for system administrators to report, to perform routine maintenance and respond to issues such as piracy and things like that. So this is kind of more specificity here for allowances for monitoring without notification. This is very rare that this happens, and we have processes in place. So one, it can be monitored if the users voluntarily made the content accessible to the public, and that's, most obvious example is if you publish a web page, anybody can look at it. There's no notification to whoever authored that page that somebody's going to be looking at it. Two is it reasonably appears necessary to protect the integrity and security functionality of the institution, or to protect from liability. There's a reason to believe there's been a violation of laws or policy. An account appears engaged in unusual or excessive activities indicated by monitoring, general activity usage patterns. We get a directive from law enforcement, or there's a specific complaint where there's a reason to believe there's policy violation. And so just a couple additional comments here. In 4, the most common case where there would be unusual activity is we're monitoring network flows, so that's general patterns in network traffic. And if those patterns match what we know to be exhibited by an infected computer, we will block the computer on the network. We actually aren't, even in that case, looking at content. That almost never happens. It's usually we block the computer, we try and figure out who the owner of that computer is or who the responsible party is, and we work with the person or their department to get that remediated. And so even in that case, we don't even have to go in and look at content. Excuse me. And then if there are cases where we are going to do monitoring without somebody's consent, Teresa Simmons, our Chief Security Officer, and myself have to sign off. Usually we're both coordinating on that. And then we also involve General Counsel's office, and then typically there's somebody else involved, like a provost or a department head or something like that, so that we have a lot of internal checks and balances, so we're not just going in and looking, and we're being sure that when we do look at content without notification, again, which is very rare, that we follow the process and we're not being kind of flippant about it or being too casual about it. We take it very seriously. Open records concerns. What constitutes a record? Which of the records are open and which are not? And what about records stored on my personal device? And this is from the records, the internal auditor's website. The top is a century code, which I'm not going to read, but I will go through 2, which is kind of a better summary, easy, a little more accessible. So records, anything your office created, acted on, receives for action, your office is the designated custodian of, or your office needs to document its decisions. What are open and what are not? I'm just going to zip through this. Everything's open by default. The common sources of exemption, I'm not sure that's quite the right legal word, but common things that would make things not open are FERPA, HIPAA, intellectual property, IRB regulated data. There's more than that, but those are probably the most common ones that people would come across. Records and personal devices. So records are record regardless of where it's stored. Storing records on personal devices may open them to open records searches. If you're asked for a specific record as a part of an open records request, you must produce it regardless of what device it's stored on. So if you have a record that's stored at home and you're asked for that device and it's on your personal computer, you still have to produce it. It doesn't matter where it's stored. Or if you happen to use your personal email account for work and there's an email record that's a work-related email and you're asked for it, you have to produce it. It doesn't matter where it's stored. Does IT take care of retention? No, we do not. We don't look at the content of the data unless it's under the previously described scenarios. And also important to note, retention rules are not medium specific. So there's no retention policy for email per se. It really depends on what the content of it is. There's no record retention rule for a piece of paper. It depends on what's written on there. So if you have a contract written on a piece of paper, a signed contract, that's going to have different retention requirements than a piece of paper that you took notes on during a meeting or you doodled on or something like that. Both of those are records, but they have different retention rules, and they're both on paper, but the medium does not determine what the retention rules are. And there's a retention schedule on the internal auditor's website that has, there was a committee several years ago that kind of got together and put together all these retention rules. So there is a however. For systems that we run, we are responsible for making sure that your data is not lost due to malfunction of hardware or loss of physical facilities or other situation like that. Also for Blackboard courses, after a class is done, we make an archive of it. We retain the duration of time that we retain those archives for was coordinated with the retention rules for student data. And so we're not going to throw out an archive prior to the date that we're supposed to keep it. So we do keep those archives, and that has been coordinated with the schedule. Incidental use, what's allowed? What's allowed is activities that don't interfere with operations, burden the institution with incremental costs, or interfere with the user's obligation to the university. What is not allowed, and the not allowed is probably the more important to pay attention here. Political activity, for-profit activity, illegal or malicious activity, or activity that conflicts with other policies such as acceptable use policy. And this is just in case we need it. This is the definition of authorized use from policy. We can go back there. I kind of included it just as a reference. But personal devices for work, use for work is allowed. That there is this 1901.2 policy that covers use of those devices, and section 3.4 is the one you should look at if you're going to use a personal device for work. It does not exempt you from any records, requests, or obligations. It may open your personal content to ways you may not like, and it may obligate you to protect the data against accidental loss. So you are taking on, if you're using a personal device, you're taking on responsibility for that potentially. Yeah, we'll come back if there's questions on that. So now I'm going to turn it over to Chris for comments on open records.
Not nearly as tall as Mark. Good morning, everyone. My name is Chris Wilson. I'm the General Counsel here at the university. Here to talk about open records laws, which I know is everybody's favorite topic, bright and early in the morning. Mark has really covered a lot of the preliminaries, but we're going to talk about kind of two things. What is the open records law and how does it impact the university? And then bringing it down to the individual level, what does that mean for your kind of day-to-day operations and how you do your job? And do you have any part to play in the process of compliance with open records laws? Open records laws are intended to allow the public to view the workings of the various state agencies that operate the state government. As far as I know, all 50 states have some version of open records laws. Some of them are more restrictive than others, and some are more open than others. And in North Dakota, we definitely fall on the more open end of that spectrum. Some states, I use Pennsylvania for example, their state universities are exempt from the public records laws. Other states have, I came from Ohio, and it was a public university there, and the laws are just more restrictive as far as what you could ask for. Here in North Dakota, we're a very, very open state. And it makes it somewhat difficult to comply with. Not that we don't want to provide the information, it's just difficult to figure out. Sometimes requests come in that are difficult to understand what they're actually asking for, and trying to figure out, people tell me all the time, I want records that pertain to this. Well, we have 3,500 employees here. How am I supposed to find out every person that has a record that pertains to your record? So it makes it somewhat difficult. I understand and appreciate the policy underlying it. It's just difficult since our office plays a key role in the compliance part, actually figuring out how to comply with it. Records here, why it's so open is really, it's the default rule that just about anything you create for work purposes is a public record. We can go through all the various categories, but realistically, if you're creating it for work, it's a public record. In the event that there's a public records request, we would have an obligation to provide that item if it's responsive. Now, Mark mentioned a couple of what he called exemptions. There's actually two different categories of items that don't have to be produced under the public records laws. There's exemptions, and then there's items that are confidential. Exemptions are items that the state has indicated are discretionary to the state agency as to whether or not to turn them over or not. Those things would include donor information. We want to encourage donors. There's no doubt about that. And in order to encourage donations to the university, we like to be able to assure our donors that their information is not going to be splashed up on the front page of every newspaper. So the state has allowed for a donor exemption. It's discretionary whether or not we provide the information or not. Contact information for third parties reaching out, for third-party individuals reaching out to the university. So when somebody reaches out, we can redact their contact information, not their names, but their email address, their phone number, things along those lines. So that if it does go up on the newspaper, it's people can't reach out to them individually. So things like that. Those are what's called exemptions, and those are discretionary. So there's certain items that are confidential, and we have no discretion in that area. We have to redact those pieces, absent a court order to the contrary. The single biggest item here as a state university that we find for confidential material is FERPA protected information. That's the Family Educational Rights and Privacy Act. It's a federal law which designates that educational records of our students are private under federal law. And that means that if we have a public records law that comes in, a public records request that comes in seeking educational records of a student, we cannot turn those over. And as you can imagine, that is one of the places of highest tension between the laws. We have a policy that says everything we do should be open, and a policy and a state law or a federal law that says everything that you do with educational records should be private. And working in the contours between those two laws is sometimes how people get mad. People, the media or people who make regular requests don't understand our need to comply with federal law on that area. So other areas that would be like Social Security numbers. We can't turn Social Security numbers over. HIPAA protected information. The kind of things that you would expect. Trade secrets, things along those lines that we just can't turn them over. So that's essentially kind of what open records are. What does this mean for you? First of all, with regard to the process, if we get a public records request in, there's realistically two places on campus that handle public records requests, processing public records requests. One is our office. We do the bulk of it. The other place is the communications office. They get a lot of more, they're the point of contact for most of the media around here. We get a lot of stuff in directly to our office, General Counsel's office, who are more routine people looking for information for studies or things along those lines, and we just produce that stuff. If it's for a media, like the Forum or the Tribune or whatever, that gets handled through the communications office. They in turn route it to our office, the request for if there's something illegal about it. Now, after we get the request in, we submit the, depends on what the nature of the request is, obviously, but if it's people's emails, we handle it one way. If it's coaches' contracts, you know, we keep a lot of those right in our office just to turn those over for ease. There's a lot, it depends on the type of information, but we essentially return the request over to the group that has the information, with the directive that you have to provide this to us in a reasonable amount of time. Turn it back over to the general counsel's office in a reasonable amount of time, and don't destroy anything, obviously, and turn it all over, because we are the one. The general counsel's office is the one that ultimately responds back to the requestor with the material. It comes back to our office because we're the ones who have to review the material for determination about exemptions and confidential material. So we always, there's a lot of little exemptions and confidential information, things like the little tricks that we have to be aware of. And so that's why it has to come back to our office. Otherwise we could accidentally make a disclosure that we didn't mean to make. So then we turn it over, we're allowed to charge. Our office does a tabulation with regard to charging. We're allowed to charge 25 cents per page for hard copies. If it's electronic, we're not allowed to charge. We're allowed to charge $25 an hour for locating fee, for the fees associated with locating, but the first hour is free. Anything above 1 hour is charged at $25 an hour. Once we get to our office, we're allowed to charge for redaction time too, except the first hour is once again free. Then we charge $25 an hour for redaction time. For a typical, you know, somebody calls in and says they want, you know, Coach Bowles contract, that doesn't take us much time at all, because we have electronically, there's really nothing in there that's redactable for purposes of student information or things along those lines. On the other hand, somebody comes in and says, you know, we want an email search of this 2 or 3 people's computers, and it results in 13,000 pages. You know, we just had one in the other day that it cost us $1,600 to do the location fee, and I've estimated $6,000 for the redaction cost. You know, there's a big variance on these public records requests, and some of them, you know, wouldn't be surprised if some of you heard about some of these this summer. But those are just the big ticket ones. There are a ton of them that we get in. Now, what does this mean for you individually? You're unlikely to be involved in the actual requesting process. If somebody should make a request to you about public records, our office is the stop. You know, just refer them to our office. You can't, if somebody makes a request to you, electronic, if you get it, don't ignore it. Forward it to our office. You can't ask who the person is. You can be anonymous under the public records request. You can't ask why they want it. Who wants it and why they want it are irrelevant questions for our obligation to comply with the public records laws. Essentially just send it to our office and we'll take care of it from there. But that doesn't end your obligation, because each of you as an employee of the university has an obligation to, you know, keep your records in accordance with the record retention schedule that Teresa's going to be talking about here in a minute. But more importantly, let's make sure all our records are professionally done. I mean, for those of you who are outside of Old Main, you may think that your records may not be, you know, I'm never going to get a public records request made of me, so why do I care? You know, I'm not President Brashani. Let me tell you, as a guy who's fulfilled a lot of the public records requests here, like I said, there's ones that don't make the headlines that you might be interested in. We've had spouses make public records requests against other spouses. We've had supervisors make public records requests against their employees, and vice versa. They are records. So let's just keep that in mind when we're doing our records. This is a professional place of business, and all our records should reflect that. So, anything I'm forgetting, or I think I covered everything. So, okay, and I'll be available for questions at during the roundtable part at the end. Thanks.
Good morning. My name is Teresa Simmons, and I'm the Chief IT Security Officer here at NDSU. And Eric Miller extended his apologies. He would have liked to have been here this morning, but he had a conflict. So he sent a narrative for me to read, so I hope you just bear with me. And basically what he's doing is he's going to answer 4 questions that he felt you might have as an audience. So this is based on the NDSU Records Retention Policy 713, which can be found on the policies website. He is also the keeper for that policy, and he manages the records retention website. So there is a document out there on the website that is the schedule and retention policy that lists all the different types of records and categories they fall into and how long they can be kept. So the records management program at NDSU was established in 2009 to formalize and put structure around NDSU responsibilities under North Dakota Century Code Chapter 5446. Records management is, quote unquote, systematic control of recorded information required in the operation of a state agency. And this is the first question he had. What is a record? A record is any document, book, paper, photograph, sound recording, or other material, regardless of physical form or characteristics, made or received pursuant to law or in connection with the transaction of official business. This includes electronic records such as emails, documents, spreadsheets, etc. The key takeaway from this definition is that the actual information, not the format, is considered the record, regardless of the medium. For example, the session today is being recorded for future playback. That recording is considered a record. So if it's recorded in information in any shape or form that is used in the operation of a state agency such as NDSU, it is a record and must meet NDSU's record management policy and program, as well as state law. So why have a records management program? Records management programs preserve and ensure the availability of important information used in the course of conducting business. Those advantages include ensuring availability of information for legal, physical, historical, and administrative purposes, determining the most appropriate retention medium and location, such as should it be electronic or paper, where should it be stored, how should it be stored, should it be secured, should it be backed up. Those types of questions need to be answered when creating records. Then we need to create a file system for state records. This will provide consistent order and understanding of records across the institution. It also allows for efficiency through optimal productivity, minimizing costs, improving storage and retrieval systems, and protecting agencies from litigation regarding record-keeping practices. The records management program consists of the following steps. And here he's outlining the general parts of a records program. First one is records inventory, which is a master list of all the types and categories of records NDSU has. And we recently pulled that up this morning, and it's about 25 pages long. So if you think there aren't many types of records that are kept at NDSU, you'll be surprised to find that that's not true. Records series description. Each one must have a description and a definition. For example, accounts payable, annual budgets, class syllabi, etc. You need to determine the administrative value. So in other words, why does it need to be kept? Is it legal, audit, historical, administrative, etc.? And then we need to establish a retention schedule. And this retention schedule establishes the master list for each record series, how long it should be kept, and the proper method of disposal. Certain methods of disposal do vary, especially per type of record or per series. Records disposal and archival. This is an annual records disposal report that is produced in July of each year. This lists all of the record series and which year and prior can each respective record series be disposed of. For example, accounts payable has a records retention period of 10 years. As of July 2013, any accounts payable items in that record series from June 2003 and prior can be disposed of. And the last step is managing a records series and retention schedules. That is, the initial inventory and retention schedule has been established. Now it is identifying new records, updating old descriptions, understanding new mediums in which we might have records stored, and ensuring they are captured in the records management process. So what is an employee's role in records management? He states we rely on the employees and management to identify needed changes and communicate with the records management coordinator. With the breadth and depth of activities and changes at NDSU, employees are key to maintaining the integrity of the program. Each employee is responsible for the records entrusted to their care. This includes physical and electronic forms. Scenarios to consider include developing new records and notifying NDSU records management to update or create a records series description and appropriate disposal and reporting according to the annual records disposal report. Eric also stated that if you have questions, you can direct them to any one of us and we'll be sure to get them to him, and he will be glad to respond to them. Just be sure to leave your name and an email address or a phone number along with the question. So, thank you.
I'll quick add, the internal auditor's website is accessible on the A to Z index on the NDSU website. Just look under I, and that you'll also be able to find links to the records retention schedule that we've been referring to.
Please join me in thanking our speakers this afternoon, or this morning. At this time, we'd like to take questions from the audience, but I must interject one before we begin. We had an email that came in from the NDSU Forest Service, and they ask, if the NDSU Forest Service has a website and a Facebook site, do we need to have a backup copy of every day in the event someone asks for previous pages under the open records law?
The public records laws does not have any requirement that any records be kept up until the time that there's actually a public records request. So with regard to whether or not a website, what the records retention requirements are for a website, you have to look to the schedule, record retention schedule. And as I said here, I have the foggiest idea. But if there's an archive requirement for websites, you would follow the record retention schedule on that, not the public records law. We don't have any obligation, we don't keep any records for public records purposes up until the time there's a request. Once the request is made and we've received the request, then we have an obligation to not dispose of any records that are responsive to the request. So, I leave it to the IT folk and the record retention schedule for determining what would be in fact the schedule for archived web pages, I guess, or out-of-date web pages, which I don't know.
And it all depends on the content. It all depends on the content. It's not about whether it's a web page or whatnot. It depends on what content is on that. And that's where, like the records retention schedule, it's important. So for your areas to know what kind of content you're managing and to match it up with the retention schedule. The retention schedule indicates not only how long you have to keep something, but there's some content, I believe, that needs to be destroyed after a certain time. So you may have obligations to destroy records after a certain point. I don't know the specifics on that. I'm going to call on Karen, though. Financial data maybe has a requirement to be destroyed after a certain time?
Yes, it does.
Yeah.
There's different rules.
Different rules. So there are cases. So look on that. It's important for your area to look on that schedule.
Once you fulfill a records retention or open records request, do you have to keep what you sent?
No, the question is, I don't know, maybe we can hear it, but once you've fulfilled the public records request, do you need to keep what you've sent? The rule is that, once you've fulfilled the public records request, those records go back into their regular retention cycle. I believe that the records retention schedule actually includes a 1-year requirement for the request itself. Now, that being said, it's typically advisable for us, and we do keep a copy a lot of times of the thing that we produce, because somebody can make a complaint for at least 30 days after the date of fulfillment that we didn't do it properly. And so we'd like to have a record of what it is that we produce. Does that always happen? No, it doesn't always, because sometimes those records have to go back in, or if it's incredibly voluminous. I mean, we're not keeping 30, 40,000 pages. Our office is only so big. I mean, so we'll have to, sometimes we get originals in and they just have to go back. So it depends on the circumstances, but legally you don't have to keep, it goes back to being whatever its cycle is. But the request, so if we get the request in, we have to keep that for 1 year, the actual document.
I have another open records request question. I'm fairly confident that like human subjects data can be kept confidential and out of open records requests. However, my question pertains to the IRB protocol form, which is essentially the investigator's plan on how they're going to conduct their study. The form itself does not contain any confidential data. Can the protocol form be kept confidential, or?
The complicated answer is I don't know.
Considered intellectual property, perhaps?
It could, yeah, I mean, those are one of those things, those gray areas. I mean, certainly there's no human, on the form itself, there wouldn't be any subject information. So I'm probably leaning towards the fact that it probably would be public, but I couldn't say yet. If there's trade secret, some other reason why that it might be. We'd have to, some of these things we have to look at in more depth, and it's kind of not conducive to like a shoot from the hip kind of answer. So if you want to bring that to my office or shoot me an email about it, I'm happy to look at it more in depth.
Okay, another question. Where do you see the future of data collection and data privacy going forward? Lots of collection and no privacy?
That's a little bit facetious, but not entirely. And just in general, I mean, Google has so much information on everybody in this room. It's just crazy. And the NSA probably has it all too. And it's just a lot. And I think that's one of the reasons it's important to kind of be aware of these things and steps for protecting yourself and being sure. We talked about being careful what you put in an email, your work email, because it could be public. You also may want to think about that for your personal stuff. And Facebook, for example. I think we were on we had the social media group that was looking this past spring about how social media. And I think a lot of people think that there's a lot more privacy there than there actually is, and stuff gets leaked a lot. We've had issues with that too. So be mindful. When you're communicating electronically, it's not like it used to be when there was a conversation, in the hallway or something where it was somebody would have to repeat it. It wasn't accessible to the world. We're just very close to having anything accessible to everybody by accident or on purpose.
And I think this has, we haven't talked much about the classroom or our students or how we teach, especially, when most of us are teaching increasingly with emerging technologies. And so in terms of another thing to think about in the future is how are we, a lot of instructors are facilitating or using new media in the classroom, such as when we teach in our Department of Digital Writing course, or we're teaching students how to write for the web, or we're teaching students how to communicate with people and collaborate with other writing students in Europe, or we're engaging our students in community learning projects where they're taking their own writing and their own projects out into the community. And so we get into all sorts of questions regarding what records are, what even FERPA records are. When does that student's work become an academic record? How do we keep them engaged with the community, both local and global, while still thinking about privacy and records? So, in terms of the future there, I think we have a lot of questions to ask in terms of pedagogy. How do we sort of balance the tension, the sometimes tension that emerges between innovative, which I guess you could read as incorporating digital technologies into the classroom and into our research, and how do we not sort of get in trouble or violate policies and laws that were ultimately written before the digital age, right? Most of these rules, i.e. FERPA, was this sort of don't put students' names and their grades on a bulletin board. So I think that's something also that we need to think about in terms of future of data.
Yeah, and the web has a long memory, and therein lies a big part of the problem. Some of our students don't have the discretion in some of the decision making they make to make good decisions, but the web is going to remember it. And so comments that would have been made and forgotten in a verbal setting in a classroom now have a long memory because they're online. I've literally seen cases where classroom chat ultimately resorted to a written complaint based upon a written document that somebody said to me. Would that have happened in a more traditional classroom setting? I don't know, but those are the things that we grappled with during that task force, and we came up with some really good social media guidelines for the faculty to consider when they're using not just social media but any electronic media as a pedagogical tool. But I just once again go back to what Mark said, more data and less privacy. I mean, we were just chatting before this thing started. If Google can take a look at all your web browsing history, compare it with your email history, and then tap into your Target card about everything you buy. They have a pretty holistic picture of who you are. And I don't know that existed 10, 15, 20 years ago. I don't know where it's going from here, but not going to be good. So, not to be too cheerful about it.
And I think the consideration then that needs to be made, both on our end, and so we're having this open forum to talk about all of the freaky ways that what we do on a daily basis is subject to open records requests. I think we have a similar responsibility to students to help them understand the long memory of the web, help them understand how to interact in those environments and so on. So, and I think our students, by and large, have a pretty striking lack of knowledge in terms of their rights, in terms of fair use, and so on. So I think some of the things that our university has been working on in terms of developing best practices and increasing knowledge of faculty, staff, and students is really important moving forward.
Yeah, one of the things that we came away with was not only just the social guidelines for faculty, but a separate document that would tell students what their rights are, so that they could understand, because a lot of them just aren't going to understand what their rights under FERPA are, or rights in these classrooms, and so to give them some disclosure with regard to things you could say no to.
If anyone's interested, those social guidelines for pedagogical learning are out on the IT security website if you want to go up and take a look at them.
Are there any concerns for us that use Dropbox or Google Groups for our work, other than the obvious of not giving confidential information?
Yes. Well, and if you're using a personal Dropbox account, I don't know what the terms are for that. So there could be stuff that you're doing content you're putting there that could be, the terms there might be in conflict with what your responsibilities are for your job and what NDSU or the state might put on you. And so I think the big thing is we have an institutional Google Apps for Education license, so that's very close feature-wise to Dropbox. We want to try and have services, we're trying to get services that have been vetted with like the general counsel for the license and that we can support, that we offer, so that you can be in a place where you don't have to worry about that, we worry about it for you. And you could, I don't know with your account, if you put stuff there and you forget your password, what are your options like in a Dropbox? And it's content that you need to get. If you do it on a service that we're managing, we can help you recover that. So there's a lot of stuff with like preservation of records that you need to be a steward of, or things like that, that if you're doing it with a service that's been supported by us and with the license vetted by general counsel, we provide a lot of supports that you're on your own for when you're doing your own thing. And I realize, like, when we're talking about, you know, social media and stuff like that, you know, there's only one Facebook. There's not really, you don't really have alternatives. If you're going to do something teaching with that, for example, if people are teaching with that, they don't have a lot of alternatives in some of these cases. Or if you're trying to be on the cutting edge of stuff and do some research on how some of these tools might work in your, might work for you, you know, that's one thing. But so we can't. It's, you know, we're trying not to have a hard and fast rule that is across the board, because it doesn't work in all cases. We do so many different things at this university that it just wouldn't always work. But try and use our services whenever you can. And the safest of all is our Windows file services, the S, the U, and the X drive for stored content, because that's managed internally, it's stored internally. We have control over it. We know where everything is, and we can provide the most support for that.
Another thing with that is we also know who has access to your data. If you do go out to Dropbox or any of these other services that are out there, there may be administrators that we have no idea who they would be. They don't have to follow the same rules that we've set in place. So they would have Snowden like people out there that would leak stuff out, and we haven't had an issue in over 10 years where somebody's looking at data that.
Yeah, internally, I've been here 10 years, and we've never had an issue where people are abusing their privilege is to look at people's content. It's just not been an issue. We take it real seriously internally. But I can't vouch for other third-party people, and that's why it's really important, again, to have legal review it, so at least there's a legal contract in place.
The other thing to keep in mind is, if any of you are dealing with research that could be subject to export control, a lot of these things, if you're storing on a third party, they may be backing up overseas, they may be storing overseas, and you may have accidentally just had an export control violation. So it's one thing if it's
penalties for that.
Yeah, that's not. I mean, a FERPA violation we try and avoid at all costs. But at the end of the day, realistically, if somebody's paper gets sent overseas on a backup server, that's not going to be a huge violation. If the technology that goes into some big missile gets sent to China, somebody's going to jail. So the cost there are considerable. Yeah, that literally has happened. So if you're using those third-party services for complicated, and the export controls cover more things than you would think that they would.
If you're dealing with that kind of stuff, contact me and we'll be sure.
We'll work with you.
Yeah, we'll work with you to be sure you're safe.
Just a comment with regards to records management and the retention schedule itself. It's not just about destroying items or getting rid of items. There are items on there that require archiving into eternity, I'm assuming. Being a university, we have such a large body of work that we create on a regular basis. Certainly a history there that the university wants to keep. So that is a requirement on the other side as well, that you retain or archive certain items as well.
Archiving for historical purposes, yeah, absolutely.
I know registration of records, like student records, I think they have to keep in perpetuity. That's one example.
Can you expand on the potentially undesirable effects of using a personal device? If it coming into scope of an open records request?
Well, if you're using it to do work, you know, if you could find yourself in a situation where you're being forced to have could you be forced to have a third party do a search of those stuff? I mean, we haven't had that happen, but it could be pretty.
It could happen. I mean, that's at the end of the day. We anticipate the employees would turn over all the material that would be responsive from their personal device. Could there be a situation where somebody makes a complaint saying, no, it wasn't turned over, and there has to be some sort of verification process? Presumably, knock on wood, that hasn't happened to date, but I hope it never happens. But the best way to avoid that is use university stuff.
Yeah, and I use I have a personal phone that I'm using for work, and I kind of had a trade-off. I didn't want, I didn't want to have to carry two devices, so I didn't want a work phone, and I didn't want to have to be in a situation where somebody might say, oh, you're using your phone inappropriately, it's beyond whatever the incidental use allowances are. And so I'm using my own device, but I could be in a situation where there's a records request for what work phone calls I made, what time, and I might have to turn it over, and I decided I'm okay with that. That's better for me than having to worry about somebody coming and saying I'm misusing state property for something.
But at what level do you have to be? Does that at some point a subpoena kick in, forcing you to turn it over from a legal perspective, or? I mean,
Sorry, does what kick in?
Well, as my employer, you can't necessarily obligate me to turn over my personal devices. At some point, a subpoena would, I can get fired, I suppose, but at some point, a subpoena would kick in, I would imagine.
Haven't been down the path, hope not to.
But I think before we get to that point, for most people, it's just important to recognize you're probably going to feel compelled to let people have access to your personal device before it's at a point where somebody's issuing a court order for you to do that. At some point, you're probably going to say, well, this isn't worth it for me to keep going on this. I might get fired, I don't want to lose my job, or I don't want to have to deal with a court order. I don't have anything to hide, just turn it over. Whatever I have in there that people might see that's embarrassing is less painful for me than continuing on this, So you could be in a situation like that. So I think it's important to recognize whatever the legal line is, you might not actually feel comfortable even going that far before you're wanting to give up. So there's a pragmatic aspect, I think, to this also.
My question is for Steve. You mentioned those examples, the writing classes with overseas and things. Those different projects or different things that you worked on personally, can you kind of walk us through what the process was? Did you vet them with legal counsel? Did you take a look at the policy and kind of make your own determination? This is okay, or how did you kind of come to those boundaries, or how did you decide where you decided to stop and say this isn't worth all of the extra headaches possibly?
Yeah, so I can walk you through a couple of projects I've worked on, both as an instructor and as a student. Okay, as a student, we were encouraged to do a community learning project. So we were developing media materials for nonprofit organizations in the community. Now, this turned out to be a really successful project for many students in the course. So the opportunities it provides, of course, are really obvious. You get sort of real-world experience, if you want to call it that. You work with actual clients instead of working with just an instructor. And these are, of course, experiences that our students and our faculty value. Now, you sometimes run into issues there with probably with FERPA, because you are taking student records, evaluated student work, that is, and you are putting that out into public. And most of the time, I talked last week with some folks at the University of Minnesota who do some similar projects, and they've worked these student release forms into the course. Another project I've been working on in a similar way, but as an instructor, is called the Transatlantic Project, in which writing students at North Dakota State are paired with translation students in Western Europe and now Africa and China. And it's a really valuable opportunity for our students to connect with others in sort of real-time, real-world translation projects, learning, of course, more about their own writing, their own culture, and certainly other cultures. Now, one of the challenges with that is that you need to connect students with one another. You need to provide a real-time workspace for students to join in on texts and edit texts together. And oftentimes also in this assignment we're doing scaffolding, so something they've written in Unit 1 that has been evaluated by me. I'm of course not releasing grades or evaluative comments to outside parties, but they're certainly releasing something, an evaluative piece of work out to the interwebs or whatever. And so the projects like that are, some of us would say are innovative, or are doing things that a lot of guess in terms of the public face of the university we want. Right? These things are attractive to attract new students and to say we are in fact student-centered and innovative in our pedagogy and research. Sometimes run into those issues. And so I think in terms of considerations, Luke, we've turned a little bit more toward, I know one of the things we mentioned in our committee this last semester is being very upfront in terms of the course, saying, in this course we will work with social media, here's why, and so you may need to think about this before you choose to take this course. Or offering students alternatives if they do not want to make their work public in the class, or going to more formal procedures and asking students to sign, I'm okay with this, just to sort of keep all your bases covered. So I think this is one of those issues where pedagogy is a few steps ahead of policy, and we need to sort of sometimes backtrack and sometimes push the envelope.
Okay, at this time, I'd like to thank our panelists and our speakers.